All right, good morning. Welcome to the 294th District Court. I am Judge Chris Martin. I'm going to call your names for the docket. When I call your name, please say present or here. Before we begin doing that, please make sure that you are maintaining all social distancing. Make sure that when you're in the hallways, you adhere to strict social mitigation guidelines. No crowding in the hallways, no crowding in the restrooms or the elevators, okay? All right, Joel Downs, and the record will reflect that Mr. Downs is appearing via Zoom today. Mason Oshie. Michael Hall. Kendrick Mitchell. Cameron Roberts. Kobe Cole. Russell Goss. Amber Martin. Raymond Howard. Raymond Bernard Howard. Brianna Musgrove. I have a note that Ms. Musgrove is to appear via Zoom. Let's see if she's, however, I do not see her in the waiting room at this time. Damian Wilson. Damian Ray Wilson. Matthew Kearns.
Judge Matt Bingham on behalf of Mr. Kearns, and he's present here in the waiting room as well.
Is he with you in your office, Mr. Bingham?
No, sir. He was on the screen just a second ago. He disappeared.
Is he the one that's labeled iPhone?
That's it. Yeah.
Okay. All right. We'll call him back here in just a moment. Thank you for that.
All right. Yes, sir.
Wendy Ledoux. Clifton Gross. Clifton Nasir Gross. Johnny Cooper. Johnny Jude Cooper. Aurora Halamka. Aurora May Halamka. Any idea, Mr. Manning? Coleman Raspberry. Thanks, sir. Logan Murrow. Logan Dakota Murrow. John Hawley. John Lee Hawley. Is Mr. Murray leader here? Blake Ekrit. Timothy Latham. Ty Hazelbaker. Ty Allen Hazelbaker. Travis Skinner. All right, Mr. Skinner, you're set for 10 a.m. Your attorney may not be here until that time. All right, is there anyone who is in the courtroom whose name I have not called? Your name, sir?
Judge, Mr. Smithy is not on the docket this morning. We had emailed Ms. Abraham to appear by agreement with his counsel to amend his conditions of probation.
Okay, thank you. Do you have that cause number?
It's CR 17-00304. And I had the amended conditions on it. I have to sign those.
Thank you, Mr. Hill. All right, council, do we have anyone that is ready?
Judge, Mr. Kearns and myself, ready to proceed. If the court's ready for us, we're ready to go.
All right. All right, court call CR 2130, State versus Matthew John Kearns. I believe we're set for docket call today, Mr. Bingham.
That's correct. And we had previously, we were there a couple weeks ago, had some pretrial motions that we were going to urge this morning. I talked to Mrs. Curry. She said, I guess I thought she was going to be on the hearing, but she said that they were going to inform the court that they were moving to dismiss the case and then represent it. They had some problems in their indictment.
Judge, that is partially correct. We are going to ask this to be reset to another docket call. There are some issues in the indictment. We plan to represent that. However, for Mr. Kearns' benefit, we are not going to dismiss at this time. That would require the repost of the bond. We can just carry it over to the next docket call. We believe that we can put in an amendment with the grand jury before that next session.
Did you hear that, Mr. Bingham?
No, sir. I couldn't hear.
And if we'll just turn that microphone on. I'm going to do my best to repeat what Ms. Heisel said.
All right.
Ms. Heisel indicated that she believed that that was partially true.
Okay.
And what she was requesting the court to do was to pass to another docket call. She believes that there's going to be a representment to the grand jury to fix the issues in the indictment. And she thought it would be to your client's benefit rather than having to post a new bond.
We appreciate that, and we have no objection to it being passed to another docket call.
Okay. Mr. Kearns, I'm going to give you a date, and this will be the only notice that you receive from this court. Mr. Bingham, are you available on December 8th?
Judge, I turned my cell phone off. It's coming back on and I'll check. I'm always afraid it's going to go off during the hearing. Yes, yeah, we're fine for December 8th, Judge.
Okay, then what we'll do is set Mr. Kearns for docket call on December 8th at 9 a.m. And Mr. Kearns, as I said before, this will be the only notice that you receive from this court. And you're ordered to be in court on that day unless there's an agreement or some issue that'll be brought to the court's attention and a request to appear via Zoom. Otherwise, the court would expect Mr. Kearns in the courtroom on that day.
Thank you, Judge. We'll be there. I appreciate it.
Thank you, Mr. Bingham. Anything further?
No, sir. Thank you.
Anything further from the state?
No, Your Honor.
Okay. All right. You're excused. Thank you.
All right. Thank you, Judge.
You're welcome. All right, counsel, we have anyone else that's ready? Mr. Raspberry, make your way to the podium, please. CR 2190. Go ahead, Mr. Manning.
Judge, we have received a plea offer. I'd like to take an opportunity to go over that with the client, go over the discovery. So if we request a pretrial setting out normal setting date.
Are there any contested pretrials at this time?
I spoke to the state about some potential ones. We should be able to work those out if we need to proceed.
So you're asking for an additional pretrial?
Yes, Judge.
Any objection from the state?
No, Your Honor.
All right, court will set Mr. Raspberry for an additional pretrial setting. Mr. Manning, do you believe you would have enough time if the court were to set you on Thursday, November 5th?
I believe that should be able to Judge.
All right, court sets Mr. Raspberry for pretrial on Thursday, November 5th And do you anticipate that there's a possibility of a plea on that date?
There may be, Judge, I need to speak to my client. Judge, I see that it's actually set in the 86th in the morning and afternoon.
You available on the 3rd? All right, the court will set for pretrial on November 3rd. Mr. Raspberry, once you receive a copy of this setting that you've signed, then you'll be free to go. Mr. Cole, I need you to report to the pretrial release department. There's some paperwork I need you to complete. You can come on back here and go with Ms. Burns here.
Judge, right now, Mr. Smiley,
Mr. Smythe, if you'll come up. Is it Smythe or Smithy? Smithy. All right, this is cause number CR 17304, State of Texas versus Zachary Clayton Smithy.
Judge, just for the record, the state has previously submitted to your office a motion to withdraw the MTA in this cause and the warrant. And that, I believe, has already been signed off on. This is just the amendment to conditions that are a condition of us continuing him on his probation.
Okay. And Mr. Hill, if you will, just go ahead and make an announcement for the record.
David Hill or Zachary Smithy.
All right, Mr. Smithy, if you will, raise your right hand. Mr. Smithy, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand. All right, Mr. Smithy, I see here that there is an agreement between you and the state to amend the conditions of your community supervision. This amendment is going to include additional financial obligations and going to require you to serve an additional time of imprisonment of 9 days in the Van Zandt County Justice Center on various dates laid out. Have you reviewed this with your attorney, Mr. Hill? And this is the agreement that you want the court to approve? And has anyone threatened you, forced you, or pressured you to make this agreement to amend the conditions of your community supervision? And Mr. Hill, you have gone over the rights of your client with him?
I have.
And you believe that he's doing this intelligently, knowingly, and voluntarily?
Absolutely.
Go ahead.
And I just, a clarification, I believe that the first paragraph related to finances is just an adjustment of the amount of pay each month, not additional assessment.
That is my understanding, Your Honor.
Okay, and so Mr. Smithy, you understand that you're going to have to submit yourself to the Van Zandt County Justice Center at the dates and times laid out in this order. You understand that? And you understand that your failure to do so would constitute a violation of the terms and conditions of your community supervision? All right, the court will find that Mr. Smithy has voluntarily entered into the amendment to the conditions of his community supervision. The court hereby approves and signs this order. All right, I'm going to have you step back here with the probation department and make sure that you get a copy of this. When you go to the Van Zandt County Justice Center, we'll need to have a copy of this with a valid picture photo ID. Failure to show up with those things will result in them refusing you access to the jail, which could constitute a violation of your community supervision. Okay? All right, then anything further, Mr. Hill? Okay, all right, then we'll be adjourned in this matter. You come back here and have a seat, and the probation department will get you when you're ready. Thank you. Thank you, Mr. Hill. Mr. Down, I'm going to ask you to unmute your device again. I had to mute you earlier because there was some background sound.
Sorry. I'm
It's
sorry,
okay.
Your Honor.
It's okay. All right, this is cause number CR 2210, State versus Joel Downs. Mr. Downs is appearing for arraignment today with permission of the court via Zoom. Mr. Downs, is it my understanding that that you intend to retain Mr. Matt Bingham to be your legal counsel in this case?
Yes, Your Honor.
And do you believe that you'll have him retained this week?
Either this week or next week, but yes, I will.
All right, Mr. Downs, I'm going to reset you for Tuesday, November 3rd for arraignment. And this will be the only notice that you receive. So make sure you write that down, November 3rd at 9 a.m. for arraignment. And I would expect you and Mr. Bingham to appear unless Mr. Bingham files a waiver of arraignment.
Yes, sir. Yes. Thank
All
you.
right, so we'll see you on November 3rd at 9 a.m. with Mr. Bingham or another legal counsel that you hire.
Thank you, Your Honor.
All right, you're welcome. You're free to go.
Thank you.
Mr. Calabria, are you ready? Ms. Ledoux? Come on up, please. All right, this is in cause numbers CR 20-173 and 174. I believe we're set for pretrial today. Are there any contested pretrial motions?
We have filed no trial motions at this time, but request that the court allow us additional setting for that purpose. Been in touch with the prosecutors late yesterday afternoon. There's still some information to exchange with each other regarding the negotiations.
Okay. There being no contested pretrial motions, the court will set this for a docket call. Do you have your calendar available?
Yes, sir.
Will you see if you're available on December 8th? 8th or 10th of that week? If one's better than the other.
Tenth appears to be a better date.
Okay. Then the court sets Ms. Ledoux for docket call on Thursday, November 10th at 9 a.m. And Mr. Calabria, I'm not sure if you're aware of the court's policy, but on that day, if all negotiations have completed and the court would be expecting either an announcement for a bench trial, jury trial, or negotiated plea. All right, and then Ms. Ledoux needs to receive the yellow copy. The court gets the white copy of a reset. And there's one available up here, Mr. Calabria. We'll just need to fill that out. If there's anything lacking in discovery, the court needs that indicated there. And then we'll have her sign in the lower right. And then we'll get the white copy. She gets the yellow copy.
Thank you.
So Ms. Ledoux, once you sign that white copy and get the yellow, you'll be free to go. Okay? Michael Hall. Mr. Hall, if you'll just make your way to the podium, please. This is CR 20251. Mr. Hall, you're set for arraignment today on the second-degree felony offense charge of possession of a controlled substance in penalty group 1. Mr. Hall, are you retaining an attorney to represent you on this matter? Say that again. Have you spoken with the court coordinator? You have this morning? Okay. All right. Go ahead and have a seat and I'll recall you. Thank you, sir. Mr. Mitchell? All right, Mr. Mitchell, the state has submitted a motion to withdraw the motion to adjudicate in your case. They're asking the court to grant that and to continue you on community supervision. Court has also signed the amendment to the conditions of your community supervision. So at this time, you have no other business before the court, so I'm going to have you report to the probation department, okay?
And Judge, for the record, the motion to withdraw the MTA should also take care of the motion to withdraw the warrant. However, I am having Ms. Abney withdraw this separate document for the warrant that is out for Mr. Mitchell to take care of that before he leaves today. So Mr. Mitchell, if you'll hang around and get a copy of that just to make sure you're cleared out.
Okay, so come over here and have a seat, and Ms. Burns will speak with you in just a moment. Cameron Roberts. Come on up, Mr. Roberts. All right, Mr. Roberts, you're currently on community supervision in cause number CR 19290. There has been an amendment to the conditions of your community supervision submitted to the court, waiving your confinement in a substance abuse treatment facility, thereby alleviating your need to report to the Van Zandt County Sheriff. So the court this day has signed the amendment to the conditions of your community supervision. Come over here and have a seat, and whenever probation has an opportunity, they'll speak with you and you'll be free to go. Mr. Stevens, Mr. Adams, either one of you ready to go?
I completely ready to go.
Is that Mr. Ekrit?
Yes.
Blake Austin Ekrit, CR 277. Come on up.
You get them all, Judge?
I get them all.
Okay.
All right, Mr. Egert, sorry about that. All right, Mr. Egert, if you will, raise your right hand, place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Am I pronouncing your last name correctly? All right, you may put your hand down. All right, you are Blake Austin Egert, correct? Mr. Egert, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Okay, and are you currently undergoing treatment for that disorder? Are you on medication today? In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you? You feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Anything about this plea agreement and the paperwork that you've signed and read that you do not understand? Mr. Stevens, do you believe your client to be competent today?
Yes, sir.
And you've explained to him all of his legal and constitutional rights?
Yes, sir, I have.
Mr. Egert, you are charged by indictment with the third-degree felony offense of possession of controlled substance in penalty group 2, greater than or equal to 1 gram, but less than 4 grams. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also a fine not to exceed $10,000. Do you understand that full range of punishment? What that means for you is that if there's ever a sentence handed down by the court would have to affix your sentence somewhere between 2 and 10 and a fine not to exceed $10,000. You understand that? Now, it appears to me that there's a plea agreement in this case wherein you're going to plead guilty to this charge in exchange for the state's recommendation that the court defer a finding of guilt in your case and place you on community supervision for a period of 2 years with a $2,500 fine, $180 restitution, plus court costs and reimbursement fees of $785. Is that your understanding of the plea agreement, Mr. Egert? Yours as well, Mr. Stevens?
Yes, sir.
And Mr. Stevens, you've explained to Mr. Egert the advantages and disadvantages of a deferred adjudication plea.
Yes, sir, I have.
And he understands that the court would have the full range of punishment up to a maximum 10 years confinement if he violates his community supervision.
He understands.
All right, Mr. Egert, to the third-degree felony charge of possession of a controlled substance in penalty group 2, how do you plead? Say it louder. And are you pleading guilty because, in fact, you are guilty and for no other reason? All right, I'm going to recall your case. I'm going to recall your case in just a moment, and I don't need any hesitation. That's okay. I'm going to recall your case, and I want you to speak with Mr. Stevens.
Have any questions about whether it's
Yeah, that's the safe play right there.
Younger my client's good to go. He's just nervous.
Okay.
That's what he told me. So,
Okay. And I can understand and appreciate nervousness. What my job today, Mr. Egert, is to make sure that you're aware of all of your legal rights and to make sure that you understand that your plea, that I got to understand that your plea is free, that it's voluntary, and that you're not pleading guilty just to get a good deal. I have to ensure that you are guilty of the offense. If I'm not sure of that, then I'm not to accept your plea and you're to resolve your case via a trial. So that's my role today. All right. So I'm going to back up again and ask you, and you'll recall that you're still under oath. So, Mr. Egert, to this charge, you've already pled guilty. Is that still your plea before the court? And are you pleading guilty because you're guilty of committing that offense? And no one's forced you, threatened you, or pressured you to make you feel like you've had to plead guilty to this charge. Is that right? All right. Then the court will accept the defendant's plea of guilt. Mr. Stevens, is there any objection to States 1?
no objection.
States 1 is admitted into evidence. Court takes judicial notice of the defendant's judicial confession. Is there anything further from the state, from the defense?
No, Your Honor, rest in close.
right, Mr. Ekrit, based on the evidence before the court finds that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in your case. Court hereby defers the finding of guilt, places you on community supervision for a period of 2 years, assesses a $2,500 fine, orders you to pay restitution in the amount of $180 to the Texas Department of Public Safety. Court assesses your court costs at $290, orders you to reimburse Van Zandt County in the amount of $785. All right, Mr. Ekrit, have you ever been on probation before? No? You've taken the time to read over and sign the conditions of community supervision, right? So you know what's expected of you, and you know what's required of you. And you understand that a violation of any one of these terms could result in the state of Texas filing a motion and bringing you back to the court for a determination of whether or not you violated. And if you did violate, the issue before the court will not be whether or not you possess controlled substances, but the issue will be whether or not you violated your probation. And you understand that a violation of any of these terms could result in the court assessing your confinement in the Texas Department of Criminal Justice for up to 10 years. Understand that? All right, Mr. Ekrit, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the bailiff. After that time, you're to report to the probation department. You can have a seat here until they're ready, okay?
Thank you. Thank you, sir. Not be excused.
Yes, sir.
Thank you, sir.
You ready?
Mr. Hall, still for
Oh, did you get appointed? CR 2251, Michael Carl Hall. All right, Mr. Hall, the court has reviewed your application for court appointment of an attorney. The court finds you to be indigent and has appointed the Honorable Jonathan Manning to represent you. You have met Mr. Manning in the courtroom today, is that correct? Mr. Manning, are you ready for arraignment?
Yes, sir. Whenever the indictment client, his name is spelled correctly, I understand the charges against him, and this time he is pleading guilty.
All right, the court will enter Mr. Hall's plea of not guilty into the record and will set this matter for a pretrial hearing. Are you available on December 8th? We set you earlier. What time did we set you for on that date?
Judge, I set on the 8th here as well, but previously I set the 3rd of November. We have a little bit longer recess, so I can get the discovery, go over that with my client.
Yeah, so you are available on the 8th, correct?
Yes, Judge.
All right, Mr. Hall, you're set for pretrial on December 8th at 9 a.m. Mr. Manning is going to have you complete a notice of appearance form. After you receive the yellow copy, you're free to go. And you've signed your conditions of pretrial release, is that correct? Have you received those?
I haven't seen them, Judge. I can check with Ms. Burke and see if those are.
So what we'll do after you sign and get your yellow copy, come over here and have a seat, and the probation department's going to have some more paperwork for you, okay? Mr. White, are you ready on Mr. Latham?
Yes, sir.
Timothy Latham? This is cause number CR 17328. You are Timothy Michael Latham, correct? Mr. Latham, if you'll raise your right hand, I'm going to place you under oath. Mr. Latham, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, you may put your hand down. Mr. Latham, you are a United States citizen, is that correct? And you read, write, and speak English. And have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Feel like you've had sufficient time to talk to him about your case and have all of your legal questions answered? Anything about your plea agreement that you do not understand? Mr. White, do you believe your client to be competent today?
Your Honor, I went over, Ms. Lakeman's rights, the waiver of rights, I don't believe voluntarily. Also believe that he's mentally competent to understand, proceeding against here today.
And Mr. Latham, you appeared before the court on November 7th of 2017, and you pled guilty to the third-degree felony offense of evading arrest or detention with a vehicle. After hearing the evidence, the court found that there was sufficient evidence to convict you. However, the court deferred a finding of guilt in your case and placed you on community supervision for a period of 4 years. The court also assessed a fine. It was during the term of your community supervision that the state filed a motion to adjudicate and revoke, and they alleged in their motion that you violated your community supervision in 4 separate counts. Mr. White, does your client waive the formal reading of the state's motion?
Your Honor, he does wait for the reading of the motion to adjudicate. He understands what the allegations are. We went over. We did them.
Thank you, sir. All right, Mr. Latham, as to counts 1, 2, 3, and 4, as contained in the state's motion to adjudicate and revoke, how do you plead to those counts? Are those counts true or not true? And Mr. Latham, are you telling me that those counts are true because, in fact, they are true? And has anyone threatened you, forced you, or pressured you to plead true to any of these counts? All right, the court will accept the defendant's plea of true. Is there any objection, Mr. White, to the admission of the defendant's waiver of rights and plea of true?
No, sir.
Court hereby admits the defendant's waiver of rights and plea of true into evidence and takes judicial notice of Mr. Latham's judicial confession. Is there anything further from the state? From the defense?
No, sir.
All right, Mr. Latham, based on the evidence before the court has reviewed the plea agreement in this case. The court will follow the plea agreement that you've reached with the state. The court finds that you have violated the terms and conditions of your community supervision. The court hereby convicts you of the third-degree felony offense of evading arrest or detention with a vehicle. Court assesses your punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, but the court will suspend that sentence today and will place you back on community supervision for a period of 3 years. The court orders you to pay the balance of your financial obligations, including your fine, court cost, and reimbursement fees. Mr. Latham, how old are you? 23? Next stop, prison. Clear? If you violate, if you don't report, it says in here you didn't report, that's the surest way to ensure that you go to prison. All right? So if you violate and you come back before me and the state proves it, you've already agreed to do 5 years. That's your agreement. I'll just enforce it. Okay? So I want to be very clear about that. So you're back on probation today. Mr. White has worked a good deal for you. The state has allowed you another opportunity. Ball's in your court now. If you screw it up, it's on you, no one else. All right? So you've gotten a second chance here. And if you don't take advantage of it, then you're going to be a young man sitting in prison. All right? All right, Mr. Latham, you hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they carry out the terms and conditions of your sentence. I'm going to have you step forward, be fingerprinted with my bailiff, and then report to probation. You can have a seat over here. They'll call you in when they're ready. I don't see it elsewhere on the docket, so free to go. Thank you, sir. Mr. Adams, are you ready? Are you ready? Russell Don Goss. This is CR 2212, set for pretrial today, Mr. Adams.
That's correct, Your Honor. We don't have any pretrial issues to present to the court at this time. In fact, the state and Mr. Goss and I have reached an agreement as to the agreement. We finalized that yesterday, and so we don't have necessary paperwork today to proceed. We asked the court to set this for a date since at a future date.
And is it to time or probation?
It's going to be for time.
For time. Is it county time or
State jail.
state jail time? Are you available on Thursday, November 5th? Tuesday, November 3rd?
No, I'm not available. If it's a question.
In the afternoon?
Yeah. The afternoon is fine.
Okay. Well, if it's going to be the state jail time, we'll just have him report over there so he can go into custody. All right. So the court's going to set Mr. Goss for plea on Thursday, November 5th at 1:30. All right, Mr. Goss, we'll see you back on November 5th at 1:30 out at the Van Zandt County Justice Center, out at the jail. Okay? Go. Free to go. Who's the other one, Mr. Adams? Kobe Cole, CR 20208. All right, Mr. Cole is set for pretrial today.
Yes, Your Honor. We have on file motion for basically retesting the two lanes.
state?
Our only concern, Your Honor, is just going to pay for that retest. The state's already paid for it once.
I've been appointed to represent Mr. I think from, in my conversations with the staff over there, the cost of retesting is going to be off.
And the original testing was 180.
Sir.
What is it currently? What does the report currently show it weighs?
It's a few 100ths of a gram above the first degree development range.
Is it within the fourth prayer?
I think it is. Specifically, based on conversations I've had with my client about the evidence. I can't replace it.
And you believe it's going to be you've had conversations with Swiss, and it's going to be $400 to $500 to retest, and it comes in at what? 4 point what?
4.7.
4.7. Does your client have any financial means available to pay for that retesting? And he's not under oath right now, so I'm not going to, whatever he says, I'm not going to listen to. But you want to talk to him about that?
I think we can get to Mr. Coleman. We can pay that.
Is there any objection from the state if the defense pays?
No, Your Honor, as long as we're not on the loss of the retest, we do need to figure out chain of custody and everything. How we're going to get that down to Swiss.
Switch provided me with a release form as soon as you enhance the principal police department. So I can forward that, however, whatever channel it needs to go through, whether it needs to go through the Mr. Thompson's office, at Lodge.
I don't think it needs to go to the court, but okay. All right, then the court will, there being no objection from the state so long as the cost is paid by the defendant, the court will grant Mr. Cole's motion for retesting of the substance, order the defense and state to work together on ensuring that the chain of custody is properly completed from the agency to the laboratory and back to the agency. And is that order on file with the clerk?
It is.
Okay. Any additional pretrial motions at this time?
No, Your Honor, not this time.
Judge, also just to be clear, we're not testing to determine the substance, we're just reweighing, is that correct?
Well, I think it's gonna include both the retesting for identification and.
Can you make a selection of one over the other? When you spoke with Swiss, do they offer services of just reweighing?
I believe so, yes, sir.
Is the, doing both a retest and a reweigh, you know, DPS says it's 4.7 grams. Swift's is gonna have to take a certain portion to, for the gas chromatograph test on it to determine what the substance is. And taking that amount away to do the testing could affect the weight. See my issue there?
I do, but if it's within the, I question whether or not,
I don't know how much they need to take for the testing.
if it's within the margin of error, that's fine. Sure. I can find out from Swiss. I think I can. I'll call the kids and see how much they need. If it's within the margin of error, let's go ahead and have it retested.
That's fine with me.
Okay. All right, then the court's going to set this for a status on retest. Did they, when you spoke with Swiss, did they indicate how long it may take them to retest the substance?
I sure did. I did not answer. Apologies. So I could.
I mean, we could be looking at 6 months.
I didn't read the court's question, Your Honor, I'm sorry.
How long did Swiss indicate it would take to reweigh and retest?
I know they're faster than Dallas counter than DPS, so DPS is running at 6 to 9 months. Swiss is somewhere less than that. I don't know how much less. They're faster than DPS.
Mr. Adams, are you available on either December 8th or December 10th for a status?
December 10th.
All right, we'll set Mr. Cole then for a status hearing on December 10th at 9 a.m. If we do not have a report back from Swiss, then Mr. Adams, I would allow your client to appear via Zoom if that's requested.
Yes, sir.
All right, Mr. Cole, you are free to go. We'll see you back on December 10th at 9 a.m. Ready on anyone else at this time?
I'll be ready on this mark. Sure.
Mr. Ashmore, are you ready on anyone?
Looks like two of mine are happy, Your Honor, and one is having trouble with Zoom. Trying to reach Ms. Musgrove so we can straighten that out.
Well, I do see Ms. Musgrove sitting in the court's waiting room at this time. She wasn't earlier, but she appears to be there now.
And I haven't had a chance to visit with her about our plea offer, but let's just do it while the Zoom is working. Because I'm afraid we're going to lose her again.
Ms. Musgrove, can you see and hear me? And you'll need to unmute your device.
Can you hear me now?
Yes. Okay.
Okay.
Find a place to kind of set your phone down and keep it real still, if you don't mind.
Okay.
If you turn it horizontally, it'll be a better picture for you and
Okay.
us.
Okay, my lawyer keeps trying to call me.
He's here.
Okay.
Mr. Ashmore, just wheel your podium into the. There you go, right there. All right, Ms. Musgrove, can you see Mr. Ashmore?
No, sir.
You'll need to swipe left or right, and you'll see another screen.
Okay, yes, sir, I see you.
You seen? Okay.
Mhm.
And, okay. This is cause number CR 20221, State versus Brianna Musgrove. We're set for pre-trial today. Ms. Musgrove is appearing via Zoom. Court's permission. Any pre-trial motions, Mr. Ashmore?
We don't believe we'll have any pretrial motions, Your Honor. I've had a chance to visit with the state at length and my client at length. We don't have all of the video discovery yet, but we have all the police reports and all the, basically the hard copy discovery, and we're aware of the nature of the allegations. Ms. Musgrove, I just went ahead and started this hearing because I know you're having problems with Zoom and we didn't want to lose you, but essentially there's a probation offer, which may include safety or some sort of drug rehabilitation, and I'll discuss that with you more later. But Your Honor, I think right now what I would request is let's reset this for a docket call so we can have a minute to visit, not in open court, about what the state's offer is. And I'll lock that down with the state before our next setting.
Are you available on December 8th or 10th?
My preference would be either before or after that because I anticipate going to Kansas to hunt, Your Honor. Oh, the 8th actually, well, no, set for trial. Actually, that trial's not going to go. The 8th would work, Your Honor.
8th. All right, court sets Ms. Musgrove then for a docket call on Tuesday, December 8th at 9 a.m.
Ms. Musgrove, you understand that?
Yes, sir.
It will be Zooming or appearing in person on December 8th, okay?
Okay, yes, sir.
And
Thank
besides the mail, you'll get a piece of mail from our office, but this is the notice you will get from Van Zandt County about your reset date, December 8th, 9 a.m.
you. Okay, yes, sir.
Okay.
All right, Ms. Musgrove, you're free to go. We'll see you back on December 8th.
Okay, thank y'all.
Thank you. Thank you, Judge.
All right, Mr. Ashmore, I don't see any of your other clients here. You had contact with Raymond Howard or Damian Wilson?
No, and we can't reach them. Although I think Madison is trying to reach them, but.
Okay, do you have anything this afternoon at the jail?
I have a hearing on Mr. Corey Tabby, a pretrial, and I'm going to be released this early in the morning. I may ask the court to allow me to zoom into that one because I have a bench trial in Rockwell tomorrow afternoon. So that would allow me to get home.
I show that Mr. Tabby has an arraignment in 228, but a pretrial in 229. I'm not sure if there's a disconnect on that, but court will allow you to appear via Zoom pretrial.
Okay, and I don't know, I thought we arraigned him on, one of them is a tampering and one of them is the ag assault with deadly. And I've asked Andy for an apology and a dismissal. He said he's gonna work that out.
Work that out.
I'm just kidding.
He probably has choice words for you. I don't think
Yeah.
it's probably not an apology, but yeah, we'll just zoom in this afternoon for Mr. Tabby, and then we'll get it straightened out.
And if we need to do the arraignment, I've already briefed him about both matters, so we've been speaking on the phone at length about both. So
Okay.
if we need to do that at that time, that's no problem.
Okay. All right, then we'll see you this afternoon.
Thank you, Judge.
this time, Mr. Cooper.
Let's go ahead and take up Mr. Cooper. CR 2239. Court's been made aware that Mr. Cooper is currently incarcerated in the Sebastian County Jail in Arkansas. Court will reset this for arraignment. On December 8th. No, that's okay. Since he's not here, we'll.
What was the date? Were you gonna,
Yeah, he just needs to sign his conditions. Pre-trial release, give him copies. Good to go.
what was the name?
December 8th for arraignment. All right, CR 20165, Aurora Halamka.
Yeah.
Ms. Halamka, I called your name at 9 a.m. and you were not present in court. You want to make sure that you know what time you're supposed to be here, because a mistake like that could wind up having your bail revoked and putting you back in jail. Okay. All right, Mr. Manning, we're set for pretrial.
Yes, Judge, I received an offer. I have not had a chance to discuss it with my client this time, nor have we done the discovery. But I asked for additional pretrial. I don't believe there's any tested pretrial in this matter, but I do need to go over the discovery with my client before we make that announcement.
Any objection from the state?
No, girl.
All right, court resets Ms. Halamka for pretrial on December 8th at 9 a.m. And Ms. Halamka, once you receive the yellow copy, you'll sign the white copy. We'll receive the yellow copy. Once you receive that, you're free to go. Mason Foshi. This is CR 2247. Mr. Foshi, you've been charged by indictment with the third-degree offense of possession of a controlled substance. Mr. Foshi, have you retained an attorney to represent you?
Yes, sir. I think it's supposed to be Kirkland. Talk to them. They just assigned me. I think the paperwork out, but I haven't spoken.
I do not show that Mr. Knoll has been appointed to represent you. I show that in January of this year, the court reviewed your application and found that you did not have a financial need. Do you have another case, another charge that Mr. Knoll represents you on?
I think so. The first time I got here, they appointed me in, and I had this is my first time. We showed back in September of 2019, Mr. Knoll was appointed on a case that has not been indicted. But we have showed it on this indicted case.
Mr. Foshi, the court has reviewed your request for court-appointed attorney. Court did that on January 15th of 2020. And Judge Winters found that you did not meet the requirements for the appointment of counsel in this case, and found that you have the financial resources available to hire an attorney. Have your circumstances changed since January of 20?
Yes, sir.
How so?
I haven't been working. I've been in Louisiana to take care of my grandparents. I didn't even know I was supposed to be here until Friday. No one until.
All right, this is what I want you to do. I want you to step to the hallway, go down that way, last office on the left, and speak with Miss Patty Taberham, court coordinator, and tell her you're interested in a court-appointed attorney, and she's going to have you fill out some more paperwork, and then the court's going to review that.
Yes, sir.
All right, and then once you're done with that, come back to the courtroom. Mr. Adams is still here, is that correct? Working on Miss Martin, is that right? Okay. you ready, Ms. Martin?
Correct.
Amber Martin, CR 20179. We're set for pretrial today.
Let's please send here. I think we're set.
All right, Ms. Martin, raise your right hand. Ms. Martin, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God? And you are Amber Martin, correct? And are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Feel like you had sufficient time to talk to him about your case and have all of your legal questions answered? Anything about your plea agreement that you do not understand? Mr. Adams, do you believe your client to be competent today?
She's not.
And you've explained to her the advantages and disadvantages of a deferred adjudication?
That's correct.
You've also explained to her her legal and constitutional rights? It appears that Ms. Martin has been charged with a state jail felony offense of abandoning or endangering a child with criminal negligence. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
Okay, just make sure you speak up so my court reporter can hear you, okay? All right, Ms. Martin, I see that there's a plea agreement in your case where you're wanting to plead guilty in exchange for the state's recommendation that the court defer a finding of guilt, place you on 2 years community supervision, assess a $1,000 fine, and order intensive outpatient drug treatment program as a condition of your community supervision. In addition, you would have court costs of $290, reimbursement fees of $590. Is that your understanding of the plea agreement? Yours as well, Mr. Adams?
That's correct.
All right, Ms. Martin, to the charge of abandoning or endangering a child with criminal negligence, how do you plead? And are you pleading guilty because you are guilty of that for no other reason? Has anyone threatened you, forced you, or pressured you to plead guilty? Court will accept the defendant's plea of guilt. Mr. Adams, any objection to States 1?
No objection.
States 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
Nothing wrong.
All right, Ms. Martin, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in your case. Court hereby defers a finding of guilt, places you on community supervision for 2 years, orders you to pay a $1,000 fine, court costs of $290, orders you to pay reimbursement fees of $590. Court also orders you to the intensive outpatient drug treatment program as a condition of your community supervision. Mr. Adams, do you know is there a CPS case ongoing for Ms. Martin?
There is, Your Honor. Ms. Martin is participating in that. She's working her services. There is, as I understand it, all this family communication. She has taken place beginning of next year at some point. Ms. Martin has been clean and sober for a number of months now and is already participating in intensive outpatient drug rehabilitation. She's already well underway, taking the actions that she needs to take, performing the steps that she needs to do, not only to satisfy the terms and conditions of the election, but also to resolve the issues with us.
Thank you. All right, Ms. Martin, I could sit here and give you a lecture about going to prison if you violate the terms and conditions of your community supervision. But, as a parent, if I'm being honest with you, I would rather do prison time than lose my kids. So you have something really more important than your freedom hanging over your head, don't you? Do you? Do you want your kids back? So I'm not going to lecture you. If you violate your community supervision, then I'll do my job, right? But as a mother, I hope that what Mr. Adams is telling me is true, that you are working your services and that you are trying to reunify with your kids, because there's no reason. How old is Zoe now? She's 10. And Caven? Kevin? 7. There's no reason these kids test positive for methamphetamine. If you want to go out and do methamphetamine and ruin your life, you're an adult. You have that decision. You have that freedom. But these kids don't. They don't have that choice. They don't have that freedom. And they shouldn't. And you as their mother shouldn't be presenting them with that. And you're supposed to love them and nurture and protect them. And yet you put them in a position to where they've got methamphetamine in their body. And you know what that does. I hope this is the last time I see you. Because if it's not, next time won't be as good. I promise you that. Ms. Martin, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm going to have you step forward here to be fingerprinted with the bailiff, and then you're to report to the probation department with Ms. Burns.
That's all I have on the docket. So whatever that is.
Yes, sir.
All right.
We'll see you this afternoon, right?
Yes,
Mr.
we
Dunn.
will.
Well, I know that you have Mr. Dunn. We have a status of CPS records. If you want to appear via Zoom, I've got no problem with that.
No, I've got to see some folks.
Okay. Yeah, so court will have an announcement for that at 1:30.
Okay, very good.
Mr. Sanders, are you ready?
Yes, Your Honor.
Who are you ready on?
Travis Skinner. And Judge Mr. Hazelbaker was out in the hall. I think it was just an issue with him having taken into custody to begin his
Absolutely, yes. Go ahead and have him come in. Travis Skinner, if you'll just come to the podium. Mr. Skinner, this is CR 265. I believe we're set for pretrial today.
Yes, sir, that's correct. And Judge, I've got the written discovery. I know there's some videos I need to pick up, and then also the CAC video, which is watching in the DA's office. So I talked to the state, I was asking if we could reset this for another pretrial, so I can get all that viewed. I know it's November, probably just a couple of weeks, so November 10th, if that would work.
You need to watch the CAC video, and you also need additional discovery.
Yes, I think the other videos we're allowed to get copies of. I think those are all ready. I just need to get those.
What about a little longer? What about December? We're getting pretty full in November. How about December 8th?
That'd be great.
All right, Mr. Skinner then will be in this cause. CR 265 is set for pretrial on December 8th at 9 a.m.
I'm not sure if you call it or not. I had stepped out to get coffee. However, Mr. Skinner has also been indicted on failure to appear within CR 26. I'm not sure if he's been rated on that yet. I don't know.
Yeah, I was actually looking at that here just to.
Hasn't perhaps we can do that today, so go up and retrial in December.
Have you seen the indictment in cause number CR 2226, Mr. Sanders?
No, I haven't.
Judge, I can allow Mr. Sanders to use my laptop. It's fine.
Are you ready?
Yes,
All right, the court will call CR 2226, State of Texas versus Travis Lee Skinner on the charge of failure to appear, bail jumping. And Mr. Sanders, are you ready for arraignment in that cause?
Yes, Your Honor, we are. But we had a chance to look at the indictment. His name is spelled correctly in the indictment. We would waive the formalities of arraignment with the reading of the indictment and enter not guilty.
All right, Mr. Skinner's plea of not guilty is entered into the record in that cause, and this cause will also be set for pretrial on December 8th at 9 a.m. If you can make sure that the notice of appearance reflects both cause numbers.
Yes, Your Honor. I did that.
Mr. Skinner, you have not been arrested on the bail jumping, so you're going to be taken into custody at this time. Grand jury has returned an indictment in cause number CR 2226, so you're being arrested at this time for that charge. You have two charges. You have sexual assault of a child, and then you have bail jumping. Go ahead and take him into custody at this time and we'll check our records.
Does there indicate there is a bond amount set?
I don't see that in. I show that Mr. Skinner, there was a order declaring bail forfeiture on July 9th of 2020. Capias issued for the in CR 26.5, but in CR 22.26, I do not show.
Judge, I showed after indictment warrants, back on September 2nd on the CR 22. I don't see that deal.
So, Mr. Sanders, what appears to me is that Mr. Skinner failed to appear to court in July. Court issued a judgment of nisi and request for a capias in the CR 26.5 case, and he was rearrested on that case. And that gave rise to the state presenting to the grand jury a new charge of bail jumping. And the court has issued it after an indictment warrant in that case. So Mr. Skinner was not arrested on bail jumping. He was arrested for failure to appear, and the new charge of bail jumping has not been arrested on. All right, you ready on Mr. Hazelbaker?
Yes, sir. Actually, regarding Mr. Skinner, if we don't know if there is a bond amount set,
It appears to me that bail was set at $250,000.
on failure to appear. Just I'm ready to proceed, Mr.
All right, court call CR 19-141, State versus Ty Allen Hazelbaker. Mr. Hazelbaker, if you'll make your way to the podium. State will recall that Mr. Hazelbaker has previously resolved his case was to report to the Van Zandt County Justice Center on October 16th to begin his period of incarceration to serve out his sentence. Court was informed that Mr. Hazelbaker appeared without his paperwork and was denied access into the Van Zandt County Justice Center. Mr. Sanders, that's my knowledge. Do you have anything?
Well,
Different.
Judge, it was our understanding he just had to show up with his driver's license. And that's what he brought. But then I think at the jail they said that he was judged with a judgment sentence but I think what he understood was that he just had to bring his driver's license when he turned himself in. So, I mean, he's prepared to go today. I think there was maybe some confusion about Friday evening we went to turn himself in.
Yes, sir. I showed up Friday with my driver's license at 5:45 o'clock, and they said that he couldn't get the paper.
I understand. And I know I always tell everyone in here to take your paperwork and take an ID. Don't shake your head no at me. I do tell people that every day. I do. That's okay. Okay, don't shake your head at me. You understand? I know what I tell people. No, you put your hand down. I know you may not speak, and you can sit there and keep your gestures to yourself, or you can walk out. Up to you. You understand? I always say take your paperwork and make sure you get a copy of it before you go. All right? So I understand you tried to appear. So we're not here to make it worse on you. We're here to figure out how we're going to make it work.
Well, I had that paper not ready to go there this morning, but I was told I had to see it first.
That's right. That's right. So, the issue we have is whatever sentence you got, if you were accepted on Friday, you would have been serving your sentence. And so today's Tuesday. So there's a period of days there that I wanted to hear from the state on if the state wanted his sentence to be if we need to do a modified order of commitment, or if you just want Mr. Hazel Baker to go in custody today. Hang on. Do you recall what Mr. Hazel Baker's sentence was?
No, Your Honor, 32 days with 2 days credit. I believe he's going to do those 30 days flat.
That's correct. And that was to begin on Friday. And he appeared with his ID. All that is correct. Appeared with his ID, and he was refused access because he didn't have his paperwork with him. And I'm not sure if the jail if we've ever communicated with the jail to see if they should have had that paperwork. They don't want. So we're looking at a difference of Friday, Saturday, Sunday, Monday, Tuesday. Yeah, so 4 days. So I'm going to leave it in the state's court right now. What you want to do on whether or not you just would take Mr. Hazel Baker into custody now and give him credit for attempting to submit himself, or we can do a modified order to extend for an additional 4 days.
Judge, since he did make every attempt to turn himself in as ordered, we have no objection to him just getting credit for those days. He is here. He would go into custody today. We'll give him credit for those and just have him be released on the same day as scheduled.
Okay, so I know there's
We don't have any objection to that.
I know you don't, but is there any other request? Otherwise, we just take him into custody now and we'll send the paperwork all at once.
Right, I think you're prepared to go ahead and go to custody.
You prepared now? Okay.
My wife can't be there. I mean, I have all my paperwork.
State any objection?
No, Judge, he's turned himself in everywhere. Just be under the understanding that if you don't show up, that could be an additional charge.
All right. Well, yeah, I think at this point we trust that you're going to go do it. You tried to do it on Friday, and you're here now, so we trust that. We're fine with it. So. Okay. So make sure that you have the paperwork. You have the paperwork now. You've got your judgment. You've got your ID. Okay. All right. You're free to go, and I'll tell you what. Submit yourself no later than 1:30. No later than 1:30. Okay. All right. See you. Mr. Foshi? All right, this is cause number CR 20247. Mr. Foshi, the court, having reviewed your amended affidavit of indigence, finds that you are entitled to appointment of counsel. The court is going to appoint Honorable Kurt Knoll to represent you. So you already have conditions of pretrial release. And you are currently on conditions of pretrial release, are you not? All right, give me that one, or just go ahead and have him sign today with, make sure you dates it underneath his signature. All right, so Mr. Foshi, I'm going to provide, my court coordinator is going to get you a copy of this order appointing Mr. Knowles, got his phone number on there. And I'm also going to have conditions of pretrial release for you, and that Ms. Burns here is going to have you sign, and you're going to be required to comply with all of those, otherwise your bail can be revoked, okay? And once you get this paperwork, give Mr. Knoll a call and let him know that he's been appointed to represent you. We're going to send the paperwork to him, but he may not be aware of it for some time. You may wait until tomorrow to give him a call, okay? So, did you get a copy of that? So I'm going to reset your case, Mr. Foshi, to December. Actually, no, I'm going to, in just a moment, we'll see when Mr. Knoll's coming back. Do you live in Louisiana?
Yes, sir.
I'm gonna have you come back on November 3rd, Mr. Foshi, for arraignment at 9 a.m. So that's only a week after next, I believe. Yeah, that's a week after next. That should give Mr. Knoll time to get in contact with you, discuss with you the case. All right, Mr. Foshi. Do we have a notice of setting form? All right, we're gonna bring this form for you, have you sign it. We'll give you the yellow copy, and then you'll have a copy of Mr. Knoll's information. You'll be free to go. Anything on Mr. Foshi? Okay, just want to make sure. November 3rd, 9. Once you get that yellow copy, then follow Ms. Burns through this door here, and she's going to give you a copy of your conditions of pretrial release, okay?
Mr. Hazelbaker, you're gonna have this, need to do an amended judgment with
Court having called Raymond Howard, Logan Burrow, Clifton Gross at 9 a.m. There's no parents in the court. They are not present in the courtroom at this time. Their names have been called loudly, distinctly 3 times in the courthouse with no response. The court hereby issues judgment nisi on any bonds posted, or any bond posted in this case, and issues alias capias. Court would set bond in Mr. Howard's case at $100,000 in each case. Court sets bail in Mr. Murrow's case at $100,000. And Mr. Gross, court sets recommended bail at $100,000.
I show that the warrant on Mr. Cooper has already been executed, so it still shows in the system, but it shows as being executed.
Johnny Jude Cooper, court has confirmed that he is currently incarcerated in Sebastian County, Arkansas, and I believe a detainer has been placed on him. And the court has set him for arraignment on December 8th. On Mr. Murrowleader's client today, John Lee Hawley, court received and approved a waiver of arraignment in cause number CR 2213 and set pretrial on November 10th. There is not a pending waiver of arraignment in cause number CR 2214. The court's going to allow Mr. Murrowleader time to get that correct. So, for all intents and purposes, the court will set both cases for pretrial at November 10th. I believe that resolved. Good morning, Doctor. All right, court will stand in recess until 1:30. We'll resume at the Benson County Justice Center.
Contact already about a reset for J